My name's Tom. I'm a solicitor at Owen Mitchell, and in my role, I'm fortunate enough to work with governing bodies across a wide range of commercial, regulatory, and disciplinary matters, some of which relate to sustainability too. So today, we're going to start by looking at the legal, regulatory, and financial risks that are emerging as a result of the increased sensitivity around climate in the environment. I'm going to focus on a couple of the key climate litigation cases to illustrate those risks. And then we're going to look at how sports organisations can manage those risks from a legal perspective. Now, we'll do that by looking at what an appropriate due diligence process looks like, some of the commercial negotiations that take place in relation to those contracts, and then in relation to the contractual clauses that are being negotiated as well. So let's look at the legal, regulatory, and commercial risks then. So starting with climate litigation. Broadly, we define climate litigation as any type of adversarial process, so litigation, arbitration, for example, that directly and expressly raises issues related to or arising from climate change policy, climate change practice, or climate change behaviour. Now, climate litigation is on the rise globally, and we're going to look at two of the key cases from the last year or so. But generally speaking, we're seeing claims being brought by private individuals, investors and shareholders in businesses, civil society organisations, so environmental groups, and public authorities too. Now, there's no real surprise when it comes to the types of groups actually pursuing climate litigation. But what is perhaps more surprising, and what we are seeing, is a more diverse range of targets for climate litigation and the corporate actors involved in the climate litigation. And this is important to the sports industry, because in the year 2022, in the calendar year 2022, 16 of the 38 most prominent climate-related cases were actually against corporate defendants. Now, half of those were, as expected, were against fossil fuel giants. But actually, 16 of the cases were against entities in other industries, including media and fashion. So it's not just the fossil fuel giants that are the targets for climate litigation nowadays. And sports organisations, I think, are a clear target for activist groups due to their public profile. Climate litigation against a sports organisation is going to get headlines, is going to be eye-catching, and for that reason, sports organisations really need to start taking the threat of climate litigation seriously. They are at risk of exposure to litigation in the courts, to arbitration, but also to complaints to regulators too. Now, that expected trend has already started in terms of the cases being brought against sports organisations. Complaints against FIFA in relation to claims it made about the 2022 World Cup being carbon neutral are well known. We're going to look at some of the actual legal claims that arose out of those allegations shortly. But advertising complaints largely have been lodged in the UK, France, Switzerland, Belgium, and the Netherlands against FIFA's promotion. So we'll look at that shortly. I think we've talked a lot throughout today about the reputational damage and the reputational concerns that sports organisations now have when it comes to climate sensitivities. But what we're really seeing is claims being made by rights holders and federations about carbon neutrality that are the focus point for activist litigation. We're going to briefly touch on some of the commercial risks too, and the reputational issues as well. There have been some really well-publicised reputational cases. British Cycling's deal with Shell, for example, got a lot of headlines in the last year, but financial issues too. Obvious financial issues with poor climate strategies being adopted by sports governing bodies and federations or rights holders. The risks there are fairly obvious. It's the loss of members, loss of participants, loss of consumers, the withdrawal from partnerships, deterring other partners from coming on board in the first place. So the risks financially and reputationally are relatively well known and have been quite well covered. Let's look at the climate litigation in detail then. And I'm going to start by looking at claims that are founded in company law. And this is very much from an English law perspective, but I suspect in many jurisdictions around the world, the same considerations would actually apply. So it won't come as any surprise that the majority of climate litigation to date has been directed at fossil fuel giants. Now, historically, claims related to the environment were actually pursued under the laws of negligence, nuisance, or specific environmental legislation for very isolated environmental issues, so spillages or contamination, for example. But what we're seeing now is that company law is being used to hold directors to account for their strategic decision-making, so not for isolated incidents, but for the strategies that they're adopting on behalf of their organisations. When the current Companies Act was introduced in England and Wales in 2006, there was lots and lots of discussion at the time about whether we would see an increased number of claims being brought in connection with the new duties that Act introduced into the Directors' Rulebook, if you like. Because it did introduce a duty to have regard to the environment and to local communities too, when considering a company's strategy. Now, there was no immediate deluge of claims, as people suspected that there would be. But actually, recently, in the last 18 months, 2 years, 2.5 years perhaps, the Companies Act is now being used as a foundation for climate litigation. So one of the leading cases is Client Earth and Shell PLC. And this is a case being brought by Client Earth against the directors of Shell. Now, although this doesn't concern a sports organisation directly, the principles are equally applicable to any organisation, and particularly sports organisations in the UK, just because of their public profile and the fact that they are likely to be targets for climate litigation at some point in the future. Now, Client Earth, in this case, filed what's called a derivative action against Shell's board of directors, alleging that the directors themselves, the directors personally, had mismanaged material and foreseeable climate risks that amounted to a breach of company law. Now, we're more interested in the actual substance of the claim, the actual allegations themselves, but a derivative claim is a claim where the shareholders themselves take over conduct of the company's business and pursue the directors or another piece of litigation. Now, clearly, in this case, it was a case by Shell against its own board of directors, so the directors themselves wouldn't be motivated to actually prosecute that litigation. And what happens is the court will allow the shareholders to step in and to pursue that claim. So this is a claim directly against the board. Now, the substance of the claim was that Shell's 11 directors had breached their legal duties under the Companies Act by failing to adopt and implement an energy transition strategy that aligned with the Paris Agreement. So in short, what the shareholders were saying is that the Paris Agreement creates a sufficiently clear obligation and that the directors hadn't complied with the requirements when it comes to implementing a climate initiative or a climate strategy on behalf of Shell. So how did the litigation pan out? Well, on the face of it, it wasn't actually a good outcome for the climate activists. The court decided that it was actually for the company directors and not the court to determine how to promote the success of the company having regard to climate, environment, communities. The court said it was incompatible with the subjective nature of a director's role to actually impose on the directors a specific strategy. So the court was saying here, there are perhaps 1,000,001 ways in which the board of Shell or Shell can actually comply with its environmental considerations, whether under the Paris Agreement or any other legislation that applied, and that it wasn't for the court to come up with its own strategy and impose that on the board of directors. So unfortunately for Client Earth in this case, the litigation actually failed. But I don't think that's really the full story. And although the claim didn't progress, it's still seen as a very important piece of litigation in the growing trend of climate litigation. And that's simply because the impact of the litigation was wide-ranging. It negatively affected Shell's reputation. The directors had to defend that claim personally. This wasn't a claim against Shell as an organisation. This was their personal livelihoods on the line had they lost. And the case sets a really clear roadmap for future climate-related litigation in England and Wales. And that's because the court gave clear guidance that until there is a universally accepted methodology by which climate standards and climate strategies can actually be measured, it wouldn't be for the court to step in and actually impose a strategy on a company. So as climate-related legislation develops in the future, I think this is going to be an important case for climate activists and anyone looking to hold a board of directors to account when it comes to their climate strategies. The second case that I was just going to touch on is the New Weather Institute and FIFA claims. Now, this isn't a claim before the courts in England and Wales. These are complaints that were made to the Advertising Standards Authority. The New Weather Institute here made several allegations regarding FIFA's promotion of the Qatar World Cup. The allegations broadly fall into three broad categories. So if we just look at those categories to illustrate some of the risks that exist for large governing bodies. Firstly, the New Weather Institute alleged that FIFA had ignored its own emissions reductions as an essential part of carbon neutrality. So FIFA hadn't demonstrated that it had done everything it could to reduce its own emissions prior to compensating for the remaining emissions of the Qatar World Cup. Secondly, they alleged that FIFA had used unsound methodology for its GHG accounting, breaching the code, this is the advertising cap code, by only partially accounting for the life cycle of these stadiums that were actually used to host the World Cup. And they said that this sent the wrong signals regarding the stadium's impact on the environment because they hadn't taken account of that, and they hadn't taken account of shuttle flights that were being advertised and used to attend matches at the Qatar World Cup. Now, interestingly, actually, it was on the news just 7-10 days ago that many of the stadiums that were used in the Qatar World Cup are no longer in use, and I think the phrase that the BBC came up with was that they're actually sinking into the mud already. So there perhaps is some legitimacy to those allegations. Thirdly, and perhaps more broadly, the New Weather Institute claimed that a mega event like the World Cup couldn't be compensated with offsetting, and that FIFA's claims that it could be offset were misleading. And they said that in this regard, the carbon credits bought by FIFA failed to meet some of the carbon market standards as they didn't permanently remove carbon from the atmosphere. And they said that the code had been breached by FIFA failing to reach the level of substantiation that was required for the statements that had actually been made. So a wide-ranging set of allegations being brought by the New Weather Institute against FIFA. And again, unfortunately in the UK, or unfortunately at least for New Weather Institute, that those complaints haven't actually been upheld by the Advertising Standards Authority. But having said that, similar complaints have been made in other jurisdictions, and in Switzerland I think they have been upheld to a certain degree, and it's likely, commentary from other jurisdictions is that similar complaints will be held up in other jurisdictions as well. So a really damaging set of allegations for FIFA that build on the allegations obviously that were made in relation to the giving Qatar the hosting rights in the first place. So I think we can see from the climate litigation that is emerging and the climate complaints that are emerging that there is real reputational harm or real reputational risk for sports governing bodies that now get their climate strategies wrong. So we're going to look briefly at some of the steps that can be taken to avoid climate litigation. So just to recap, the risks are obvious, aren't they? But there's the cost. They're burdensome from a time perspective in actually dealing with the claims, particularly when it comes to senior management times. But perhaps more than that, there's the reputational damage and the exposure that a public trial can bring to a sports organisation, even where claims are successfully defended. So how can organisations avoid the commercial and litigation risks? Well, what we're seeing more of is sports organisations really getting into the due diligence process before they partner with any partner, actually, but particularly in relation to partnerships with organisations that might have had questionable environmental strategies or environmental impacts. Introducing a more robust due diligence process is the key when it comes to climate issues, and the points to consider are those that have come up in sort of this morning's discussions. But what is the environmental impact of the partner? Check all of their disclosures, including historic disclosures, and where available, their prospective disclosures as well. Think about the longer term impact that the organisation might actually have on the climate. Consider scope 1, 2 and 3 emissions. There are lots of examples of organisations just looking at the brand image of a particular organisation and actually not peeling back the layers to look what lies underneath. Look at the 1, 2 and 3 emissions and check that the partner is actually environmentally sound. Does the partner have a satisfactory decarbonisation strategy in place? What sustainability initiatives are they actually a party to? What experts have they engaged to help them with their strategic decision making and the claims that are being made? Does it stand up to scrutiny? I think lots of the litigation that we're seeing now, the FIFA example being a case in point, is that people are ready to challenge any claims that are made around environment, and you need to be able to stand and substantiate your own climate litigation policy, but also those that you're involved with too. And lastly, what budget have they actually allocated to sustainability? All of this information should be freely and readily shared in a pre-contractual negotiation nowadays. And so asking for it isn't out of place, and we're seeing that more and more, and particularly in the very early stages of a negotiation. On this slide here, there's a couple of commercial clauses that we're seeing more and more hotly negotiated in the environmental context. Often referred to as cooler plate clauses, but guarantees, reporting obligations, termination and disrepute clauses are now quite fiercely negotiated in commercial contracts in the environmental setting. So we'll just have a look at each one of those. So guarantees, which are effectively commercial clauses that are included to give a sports organisation binding guarantees and commitments about the partner's climate strategy, for example, and the commitments that they've made to the environment. Now, these can help satisfy the sports organisation that the partner is committed to its climate goals, and they can be spoken about when managing the reputational risks or any reputational accusations that might be made about the partnership in question. So, for example, if somebody questions the partnership with Shell, for example, you might be able to stand behind these clauses and say, well, they've given us certain guarantees that their strategy and that their policies will change or are changing or are already environmentally friendly. Reporting clauses. We heard earlier about dashboards that are being put in place, and this is more and more common, actually, requiring both parties to disclose information, not in the due diligence phase of any commercial negotiation, but throughout the life cycle of the relationship as well. So a sports organisation might want, for example, complete transparency on emissions, on GHG accounting issues throughout the life cycle of that partnership. And this is particularly important because obviously most sports partnerships are long-term in nature, 3, 5, 8 years. You obviously want to go into that partnership thinking that you're going to have a long-term relationship. So build in the transparency that you need from your partners all the way through the life cycle of that relationship, not just at the beginning. Termination and disrepute. I'll deal with disrepute first because termination is obviously a little bit more serious and things have gone quite wrong or badly wrong by the time you get to that. But disrepute clauses have been in commercial contracts for forever, particularly in relation to athlete endorsement deals, but any brand endorsement deal is likely to have a disrepute clause in it. What we're seeing now, though, is the development of those clauses to actually bring in or bring to the fore environmental considerations too. So if a partner doesn't do what they've said they would do or calls into question the environmental impact of their strategies and their actions, a disrepute clause would actually allow for termination or for other penalties to be imposed under the commercial agreement. And lastly, termination. Now, as I say, these are usually only used in the worst case scenario, but it's important to actually have them in there in the first place because they help hold organisations and parties to account. Now, clearly in the most obvious case, they would allow for one party to terminate a relationship where, for example, the other party hasn't delivered on their climate initiatives or they haven't provided information under a reporting clause, for example. Now, hopefully, you'd never get to the point where you would need to use the termination provisions in a contract, but they're there for a reason, and they do provide for leverage in the negotiations throughout a commercial relationship.